Welcome everybody to another episode of Injustice for All with Judge Joe Brown. How you doing, Judge?
I'll manage in bad rush anyway.
All right, so I want to start off talking about Afroman.
What?
We spoke about this. So he's trending because he won his case against a sheriff department in the state of Ohio.
Oh, that one.
A jury has sided with the rapper Afroman in the civil lawsuit filed against him by Adams County deputies. WCPO 90's reporter Jay Shakur is live outside the courthouse tonight. This verdict, Jay, was read right about 30 minutes ago, and you spoke to Afroman as he was leaving. What's his reaction?
That's right. Afroman had a very emotional reaction. The jury, as you mentioned, siding with the rapper Afroman, whose real name is Joseph Foreman, in this case. Here's video from inside the courtroom as this case went on. During closing arguments, the attorney representing the deputies in this case claimed Afroman intentionally lied about and defamed the deputies in his songs, but Afroman's attorneys maintained throughout this trial it is his right to say what he wants to say. This goes back to 2022 when Afroman's home was raided following search warrants related to possession and trafficking in drugs and kidnapping. Though he was never charged, the attorneys for the deputies suing say Afroman used security video from the raid on his home and put it in a music video using deputies' likeness without permission. Again, this jury in Adams County finding he did not defame those deputies. Here's Afroman speaking directly after that verdict.
I didn't win. America won. America still has freedom of speech. It's still for the people, by the people.
Afroman becoming emotional there as he says this fight was bigger than him. It was about free speech and what he describes as corruption in this sheriff's department. I spoke to one supporter who came all the way from Dallas. I have more on that and more reaction from the rapper tonight at 11. In Adams County, Jay Shakur.
And adjournment. You're welcome. In all circumstances, the jury finds the defendant, no plaintiff's verdict prevails. So the matter will be concluded with defense verdict. Thank you, Mr. Klingler. Thank you, Mr. Osborne. Thank you to the court staff and the Sheriff's Department for security in the building. And we'll go ahead and stand in adjournment. You're welcome.
This works two ways. I've said it, preached about it, lectured on it. In America, everything is a two-edged sword. It can swing both ways. If you can rely upon what somebody puts out or somebody is in to go after them, then somebody can use it as a reply. Free speech says you have an absolute right to a public forum to discuss what your government's doing, what the agencies of your government are doing, and if somebody is acting as an agent or representative of or an officer of that government, then the government acts through them. And if the government's wrong and the only way you can express the wrong is to show the individuals that took the action on behalf of the government, that's free speech. That is, like you said, a victory for free speech. And I notice he's got the American flag rather prominently displayed. It's a little garish the way he does it, but it's a good move. Cloak yourself in the flag when the flag supports what you're doing, and that's why you support the flag. It's an American thing, and the deputies need to understand, it's like that. So,
right.
There's one thing. A sheriff's department is not immune from corruption, and we've been investigating that down in Fulton County ourselves, and we see how sometimes things get very questionable when you turn the rocks over and see what's crawling underneath. It may not look too pleasant, so it is what it is. We have that problem right here where I am in Shelby County, and I'm supporting individuals who are running for sheriff as an alternative to the same old, which has gotten too deeply entrenched and out of touch with the realities of their circumstances, and too many dead folk in jail, too many deputy jailers have gang affiliations and so forth. So somebody can speak out against that. And when you speak out against that, you may be personally involved, or it may be something you're bringing to the attention of the public saying, we need a change. And you're always entitled to put that soapbox out, which used to be a really wooden crate, and people would stand on the soapbox or stand on several so they would be elevated over the crowd, and they would stand on the street corners or at the intersection or in the parks, and they would harangue their audience with political commentary and observation. So that's all this is. This is America.
So it says Afroman is taking a stand, and I'm going to play that clip in a minute. 3 years after he was sued by Ohio law enforcement for his use of real footage of police and a pair of viral music videos, a lawsuit against Grammy-nominated rapper, his real name is Joseph Foreman, was filed by Adams County Sheriff deputies in 2023 after his music video, Will You Help Me Repair My Door, and Lemon Pound Cake used footage from a 2022 police raid on his home. The trial for the case kicked off Monday, March 16th. All of this is their fault, he says, Afroman, who was 51. If they hadn't wrongfully raided my house, there would be no lawsuit. I would not know their names. They wouldn't be on my home surveillance system, and there would be no songs. The March 2023 complaint, which listed 2 sergeants, a detective, and 4 deputies, alleged Afroman used their likeness without their permission and profited off their images. The rapper was not home at the time of the raid, but his then wife filmed it on her phone. The suit also recorded it, where they put filmed it, but recorded.
Yeah, it's not film. That's if you used the old time photographic film 35.
I know. I guess the wife was filming them from her cell phone, not talking about the surveillance.
That's called tape. It's just a Hollywood thing,
Oh, okay. The suit also claimed the deputy suffered embarrassment and death threats and are entitled to compensation.
They were there on the raid. There's no statutory immunity for being revealed to be part of a government action. There's no exemption that comes with the territory. I mean, what are they going to do? See, if by extrapolation, if they had a right to, well, they filed it, but if they had a right to a legitimate claim, then every time a citizen stood across the street and recorded what the police were up to or the deputies were up to, then if they played that on some of the social media or major networks, then somebody would be liable. It comes with the territory. You can't stand the heat, get out the kitchen. Now, I'm pro legitimate law enforcement, no problem. But I mean, the law is the law.
Right. And it was his surveillance camera, so not their body cam, because police sometimes put up the body cam videos on whatever website.
They do.
And it's like, okay, do you ask the people who are in those body cam surveillance permission to put them up on YouTube or anywhere else? So, and this is his home surveillance, and it's okay. And I think it was smart for him to make a music video, turn it into art.
That's politics. It's political commentaries, classic First Amendment stuff. And what is the term? Spock used to use it on Star Trek all the time. Sauce for the goose is sauce for the gander. In other words, what goes on one goose goes well on the other goose.
But my question is, I guess law enforcement could just raid your home without any motive?
What happens often is there's a mistake. You see, remember the last time you went into Mickey D's, Burger King, or Wendy's or something, or some fast food place, and some young idiot acted like he was doing you a favor by you being in there, and him, after getting off his cell phone conversation, deciding to help you, and he can't understand what you're saying, and he can't match the pictures of the product up with the pictures on the cash register keys. Well, a slightly glorified equivalent of that sometimes works behind the counters or behind the desk at various agencies, from banks to city hall to police departments to sheriff's departments. And a lot of times what happens is somebody is anxious because their friend girl has some kind of disaster with her friend boy or whatever, and that becomes a more concerned and depressing business, and they are negligent or just completely wrong in what they convey. And the officers may get a notification there's an outstanding warrant to be delivered, and they need to go raid this place because, and they get there and there's nothing going on, but somebody got jacked around. And see, the other thing that is not even being shown here is I know what they do when they come off with a raid. They dump the drawers on the floor. They turn the beds over. They strip everything out the closet and throw it on the floor, and it's a mess. And it takes days to clean that up. They break stuff. They get nasty. It's a crook, and they knock over lamps and break them. And sometimes they take stuff, which is why OJ had a break, by the way, because LAPD had so many complaints that they had a security squad come in and take video of OJ's home before the detectives came in to investigate, and they caught Furman planting the black leather glove at the bloody socks at the foot of the bed. They caught him right on camera, and he didn't even realize it. So that's one of the reasons that the jury didn't spend any time coming back with a not guilty verdict. They saw one of the detectives, Furman, planting evidence on the security video. So, by the way, Nancy Grace didn't report that to the American public, so they don't understand how OJ walked. Well, a lot of that stuff came out because of just this kind of thing.
So he also went on, he said that, listen, the whole raid was a mistake. And so him doing the song and the video, which it got over 3 million views on YouTube, that allowed him to raise funds to pay for the repairs that the sheriffs and the detectives did, the damage that they did to his house. Now,
There you go. And see, I think the state ought to have, I think states ought to have a proviso that says if a department serves a warrant and nothing comes out of it, then they are responsible for any damages or cost in the restoration of the premises. That's like Georgia, we've been getting into, now has a new statute that says a DA can be disciplined or removed for misconduct, which is a new thing. I think that's good. If you're going to have law, make it across the board. Everybody gets held to account.
Well, and if they don't have that law, does Afroman have a case to sue the sheriff department?
Probably not, because there is a thing called sovereign immunity. You cannot sue a sovereign unless it gives you permission. That means city, county, or municipal, county, state, or the federal government. Now, there might be some case law provision because it's something so obvious, like everybody has come to be dependent on traffic lights. So if you've got a malfunctioning street light or traffic signal that shows green both ways and 5 or 6 people collide, seriously, somebody's liable for the damages because they are relying to their detriment upon the representation that the traffic signals control the traffic. That's an old established principle. But I'll give you a classic example. I got involved in the appeal of this. Here in Memphis, what happened is for the sanitation department, they decided to hire some retarded people, mentally retarded. So one of the problems was in front of this elementary school, there was a grate that would always fill up with leaves and block the water flow into the sewer. So what the mentally retarded folk did is instead of just cleaning it up, they took the grates up so that the leaves wouldn't pile up but would go directly down into the sewer. Well, what happens is a school bus pulls up Monday morning after they did this Friday afternoon, after the kids had left. And when the first 6 kids got off the bus, they fell down 8 feet and there were broken legs, broken ankles, broken arms. But because of sovereign immunity, they couldn't sue the city, the municipality, or any agencies of the city unless they had complied with a rule that they had on the books. You had to have given written notice to the municipality, county, or state entity that there was a hazard. So they had actual notice of the hazard. So nobody had done this because it just happened over the weekend. So these 6 kids got very badly injured. And 40 some years later, some of them were still limping from the injuries, but there was sovereign immunity. I didn't try the case, but I got involved in the appeal. So that's how harsh sovereign immunity can be. So it depends on the state. But generally, you get stuck with having to pay the damages of when the police pull off a raid on your house because they're acting with the authority of the state. And in that case, they're kind of acting like they are commandeering whatever in the devil you happen to have around for interest of public peace, dignity, and order. But I think there ought to be statutes all across the board saying that if you do this and you don't get anything, you pay for the damages, because I've seen the mess that some of my clients had to clean up after a search warrant was served. They didn't get charged because there wasn't anything. And in some instances, they got what they call swatted these days, which a false report is turned in on them because somebody doesn't like them. And it gets to be a real live mess.
So, surveillance. When somebody is pulled over, you know how people pull their cameras out to record their interaction with the law enforcement. You know, when we're talking about First Amendment, freedom of press, freedom of speech. Listen, I have a right to film you and post it and make money off it. And
I would be very careful because it's dark. You may be on a dark street and your cell phone may look like a compact pistol or something, and you may get shot. There's some video out there on X where it's not really out there, but it's accessible. And when you look at it, what's going on is some nice officers pull this woman, drive her over. She's got a male passenger. And the complaint was, why did they shoot him? They had no business shooting him. He was just trying to, well, he should have held still. And the guy that was narrating the thing said, I took the time to run this through the lab, and although it doesn't show on what's out there, you can see the guy's got a gun in his hand, and he actually fires 2 shots. So people saying he had no right to be shot, you know, they shouldn't have done this, but bottom line is tell them, sir, put whatever it is in your hand down. Drop it on the floor now and put your hands in plain view. And he won't, sir, move your hands. And the woman screaming, don't shoot him, don't shoot him. And they're saying, sir, we're not going to tell you again. Put your hands, put whatever it is you have in your hands down. And then you can see when they slow it down, he pulls out a small handgun and he fires 2 shots, which they open up on him just before he fires the first of the 2 shots. They kill him, but I mean, it looks bad in the initial video that somebody's taken. But I would suggest that if you're in the car, keep your hands in view and you ask, officer, do you want me to get out of the car? Officer, if you want proof of insurance and registration, it's in the glove compartment. May I look in there? Act like you got some sense. Your life is on the line, and a little bit of common sense precaution would help you out. So you may be well within your rights, but you have people who've never been in a fist fight in their lives, like a lot of folk who might be in the car have never been in one, and the adrenaline gets to flowing, and they panic, and somebody's done in. Not a pretty picture.
Right.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God.
Yes.
Thank you, sir.
Thank you, Your Honor. For the record, would you give us your name, please?
My name is Joseph Edgar Foreman.
You are known under the stage name as Afroman, is that correct?
Yes, sir.
And you create music videos and do performances, is
Yes,
that
sir.
right? How many states of the United States have you performed in, do you think?
All of them.
All 50.
Yes, sir.
And how many countries have you performed in?
I don't remember, but not all of them, but I've been to a few.
How many live performances did you do last year, roughly?
I don't know. Possibly 250. I don't know, but I don't know. It's a lot of days, but I don't know exactly.
And you have a residence here in Adams County, correct?
Yes, sir.
You've been performing for 20 or 30 years, is that right?
All my life.
All right. And is it fair to say that one of the first big hits you had was "But Then I Got High"? An alert from a family member that the sheriffs were there searching your home, is that right?
Yes.
And you were able to turn on your phone and watch through your home security system what the deputies were doing for a period of time, weren't you?
Yes. But, I heard, I don't know what piece of paper I heard. I knew they took some money. I just knew they took some money. I knew it was 4,000-ish. I knew they took some money and they seized some money and some weed and some, I don't know what else, just minor stuff.
You knew how much money was in that pocket when you came home and saw the warrant return, didn't you?
It was $5,000 from back when I did that show. I remember it was $5,000. But anyway.
So is it your testimony that they actually took $5,000 instead of $4,390?
No, I just know. I know.
Yeah.
Whatever the merits of the case, that's awful what you're listening to. Those are leading questions, and the defense, the plaintiff's lawyers ought to be objecting all up and down. Objection, leading questions, suggestive of an answer. And unless this was the plaintiff's lawyer asking these questions, that's absolutely ridiculous. If it was his, I don't see how he got away with it, other than that the lawyers on the other side didn't know their business.
Yeah, I'm not gonna. It's 30.
You don't read like that. I'm just saying this so I don't want the public to get ideas about some lawyers' bad habits becoming legitimated by observing them with no objection. You have to say, sir, do you or do you not have any idea of whether or not any money was taken from your home? Yes. And how did you come by that knowledge? And he can tell us. You don't say on the day you came home and that you looked at the warrant return and they seized $5,000. You don't do that. That's suggestive of an answer. Hell, that gives you the answer. So the lawyer is the one testifying, not the witness, who in this case is one of the parties. That's just bad show.
I think that was not his lawyer, the other lawyer questioning him. I think
Well,
But
if he's on the same side, why in the hell would somebody ask that you got $5,000? Well, I want to see a predicate. I don't know who that is. It just doesn't make any sense unless somebody. Well, I can come up with an idea. You're trying to show that the defendant, who is the guy here in the flag suit, he had a motive for trying to go out and embarrass these folk because he wanted money to pay for
oh
his
no, I'm sorry. I
damages.
think that was his lawyers. Yeah, that was his
Well,
lawyer.
yeah, but the other side should have objected. That was awful. I mean, it's slick for him to get away with it, but to try it. But I mean, you're supposed to object, and that's not proper form. That's leading the witness. Those are very leading questions, and they not only suggest, they give an answer. And what happens is uh, one of the standard charges in most states would be, ladies and gentlemen of the jury, statements, remarks, and observations of counsel are not evidence. They're merely designed to assist you in interpreting the actual evidence and in applying the law that you will be given by the court. And
Yeah, it
see,
was
you run into that trap, but
testimony.
apparently nobody.
The testimony is actually 30 minutes. So, and I only played maybe 2 or 3, but
Yeah, I got it, but that's just poor form. Somebody should
you
have
can pick it up
objected to
from the
that.
you right from the little bit that I did play and the questions you heard, you are automatically picked it up like somebody should already objected from whatever
It's like,
side.
excuse me, Your Honor, objection. Is counsel trying to testify or is his client on the witness stand?
So basically, let me ask you this: you don't give, so you would have automatically objected in the beginning of the questioning. You don't give them time to get into the testimony. No,
Yeah, you stand up, Your Honor. You know, like what is with counsel here trying to
be the first
testify?
question, and you will object to it. It could be the first question.
Yes, he needs to lay a foundation. All right, sir, state your name, so and so and so. He did that. And then, et cetera, et cetera. Do you recall events on or about such and such day? Yes or no. It doesn't suggest an answer. He either does or he doesn't. If, on the other hand, a leading question was, not do you recall what happened on the date of so and so, don't you? See, that's a leading question. It suggests an answer. And then when he said they took forth, the money from you and you looked at the search warrant return, that's a leading question. That gives the answer. All you got to do is,
So the other side should have objected to it.
Yes. See, so my only reason for belaboring this is it's bad enough now with amateurs practicing law. And what you see on the net and in Hollywood, people get an incorrect idea of how it works. So when they see how it works, they think something really is supposed to work. They think something wrong has been going on because it doesn't match their expectations. Now, I mean, if you go to an English court where it's in front of his lordship, my lord, it is marked that the miscreant before you did on such and such occasion do the following. And see, that's England, but that's not how we do it here.
Right. Well, he's
You
happy
go
for
to a Caribbean court, you hear the same thing, and here's this guy sitting up, it's 100 degrees outside, 90% humidity. He's got on a black robe and a white wig. It looks a little weird, but is what it is.
He had a lot of supporters, a lot of white people supporting him because
it's free speech.
Yeah, it's about free speech. And that, listen, other cases are going to use his case, whether it's in the music industry or television or wherever, social media.
It's not really a precedent. It's just like slam dunk, excuse me, why'd you charge this guy with resisting arrest? Well, we wanted to search his house and we came in and he wouldn't let us in. Well, did you have a warrant? Well, no, sir. So he simply told you that he wasn't letting you come in, so you had to kick the door in, so you got him for interfering. Where in the devil did you get off that you can break in somebody's place, officer, without a warrant? Mm-hmm. You see, a lot of times that's happening, so that's not really a precedent. That's long-established law. See, this isn't setting a precedent. This just applies it. And it's sort of a rank case. So, I mean, it's a slam dunk. I bet the jury didn't stay out very long at all.
Right. Well, I want to move on to another case to bring it to your attention.
Mr. Fontenette, there was a time some years ago that there really wasn't even a question. Everyone, state's attorneys were recommending youthful offenders, probation, let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that that person had that was working in that store, that he now has just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. Mr. Font.
So let me give you a little background.
I would have said, bring them back in here. Sit down in front of the bar. Detain them. We'll come back to this in a bit.
So
and, she's being nice. You get 25 years into this jurisdiction, you can apply for probation. Whoa, that's really interesting.
I just want to read this real quick. The family of a Texas teen loses it as a judge sentenced him to 25 years in prison for robbing a convenience store. Judge Raquel West was seen torturing 18-year-old Caden James Fontenette either way, before handing out the sentence. Torching. Yeah. There was a time some years ago that there really wasn't even a question. State's attorneys were recommending youthful offenders probation. Let's give everybody an opportunity. You don't have a good likelihood of being successful. If I were to put you on probation, I'm going to sentence you to 25 years. He pleaded guilty to aggravated robbery for a 2025 incident where he and 2 others robbed a convenience store by gunpoint. The suspects were caught on camera assaulting the store clerk. Fontenette will likely be in his 40s when he is released from prison. So was that justified? Do you
Yes,
think
it
that
was. It wasn't. His circumstances shouldn't have even been considered for relief, but I guess under Texas law, he had a right to make the application as a youthful offender, but no way, no how. You not only pull off an armed robbery in collaboration with 2 other people, Not only do you pull the robbery off with 2 other people, you slap the victim around, shove guns in his face. Not only do you do that when you have a chance to be on your best, you can't even behave because you are just congenitally violent while you're locked up. You lock his behind up and he serves his time, and that's good riddance to the public. And I would have brought the mama and the family back in and given them a few days for contempt, or at least locked them up for a few hours and brought them back and read the riot act.
Well, but this is what somebody wrote, right? Replying to that video. She may have gave him a way to appeal. You can't, as a judge, say, I will give you probation, but you wouldn't make it. That is bias and a major.
That's okay. That's bullshit. It's called allocation. That doesn't even merit thing. That's just ignorance. Sorry, but I chalk this up to you just not knowing the law. It's called the allocution. 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 It is the duty of the magistrate to express the ire and outrage of the community at the transgression of community standards and the law committed by a miscreant. So you're supposed to chew him out. When you are sentencing somebody, you've got all kinds of leeways. You can call him a fool. You can call him an idiot. You can say the court doesn't think, or I don't think you'll make it because of. There's nothing wrong with that. That's because this is sentencing. It is not a procedural matter. The sentencing is up to the judge in question. It's inside his or her head, applying the guidelines. And for them to say that, that's just being candid with the defendant and stating the court's reasons.
Let me finish reading his comment. That is bias and a major no-no. She may even get in trouble in a bit for the statement. Judges are supposed to be fair. 25 years isn't. You have pedals with RA, multiple people ruining lives, getting 5 years and walking amongst us.
Oh, damn that shit. That's ridiculous. That's that bullshit that's releasing all these fools out here who are causing theft and death on the urban streets. Excuse me. I hate to offend you. Personally, maybe you are a nice person, but that's some bullshit you're just spouting right there. It doesn't work that way.
Yeah, it was on X. So they posted this attachment here. Judges should not use racist terminology.
What racist terminology?
Let me read
You
it.
act a complete asshole.
Let me finish reading it. Ethical codes, legal standards, and judicial policies strictly prohibit the use of such language as it violates fundamental principles of fairness, impartiality, and equal justice under the law. Judicial ethical obligations, code of judicial conduct. Judges are required to perform their duties without bias or prejudice and must not, by words or conduct, manifest bias based on race, gender, or other protected characteristics. Appearance of impropriety, the use of racist language destroys public confidence.
What racist language?
Duty to intervene. Judges are tasked with ensuring that lawyers and court personnel refrain from using discriminatory language. So I guess when she said, I don't think that probation is going to help you. You look like the type that's going to keep committing a crime or something.
And what's wrong with that? That may be right straight up. You're looking at somebody on the video as they behaved on the scene of the crime, to which they've entered a plea of guilty, and you have a probation report about the miscreant who's pled guilty in front of you acting a damn fool in lockup. So, you talk about him. You don't have to be. Where did they get this idea that you're supposed to be saying, baby? We understand. It's so hard. I'm having to do something I don't want to do. No, you are a jackass.
Right.
And sometimes I've heard judges say that, and there's not a damn thing you can do about it because it's not unethical.
Well, let me ask you this, because why did he plead guilty? Shouldn't he have pleaded not guilty?
Well, he had an automatic not guilty entered for him, but he chose to change his not guilty plea to guilty because they got him. They've got him on tape. He decided to pad his ass so he didn't get jacked up and get a stiffer sentence than the 25 years. So he pled guilty.
Oh, okay.
He could have gone to trial, stepped up to the plate, and tried to explain what the jury would be looking at this video when they saw this video.
Right. All right. So
I didn't need my baby boy. I didn't do anything. I had that happen one time. I said, lady, are you trying to get the court to reduce the bond for your son? Well, yes, John, I made 4 bonds a year and I can't make a 5th one. But he been a good boy. What do you mean a good boy? He's 19 years old and he's been convicted of 37 felonies since he's been 15. He dropped out of school in the 6th grade. What he always get up? Oh, how do you think he gets it?
I have another case.
I tell you what. So you don't have to go out. The court will tell you what. So you don't have to go out and buy a dark suit to bury him in. The court raised the bond up, and this was 30 years ago, to $250,000. You can't make that. And when he calls you up whining about it, you can say, baby, mama can't make that bond. And you aren't going to be able to take this up to the Supreme Court or the Court of Criminal Appeals to get me overridden because there's nobody in the county that can override me. So show the bond raised from $25,000 to $250,000. All right, next case.
I have another case. So here's the next one.
He spent 16 years in prison after being wrongly convicted of rape. His accuser, a best-selling author, is now apologizing, saying she's truly sorry. But how do you undo such a life-altering mistake? Here's Les Trent.
Tears of joy as a man wrongly accused of rape is exonerated after spending 16 years in prison. Anthony Broadwater, now 61 years old, broke down in tears when he heard the judge throw out the conviction.
Mr. Broadwater cannot get those 16 years back.
His accuser was Alice Sebold, author of The Lovely Bones, which was made into a major movie starring Mark Wahlberg.
It's gonna be okay. My dad knows I'm here.
Her rape at age 18 took place when she was a college student in upstate New York, years before she became famous. Sebold says it happened here in this 76-acre park overlooking Syracuse University, where she was a freshman. Months went by and there was no arrest. Then, one day, Alice Sebold was walking down this street and she says she came face to face with the man who attacked her. It was Anthony Broadwater. He was found guilty after Sebold took the stand and identified him as her rapist.
The people that knew me and know my character, they know that wasn't me.
Doubts about his guilt were raised when movie producer Timothy Mucciante started investigating the story as he prepared to make a movie based on Sebold's memoir about the rape called Lucky.
Anyone who reads the transcript of the trial and compares it to her book, there's quite a lot that's omitted that a reader would look at and say, you know, this doesn't add up, just like I did.
Sebold, now 58 years old, had nothing to say as she walked her dog in San Francisco, where she lives.
Anything to say to Anthony Broadwater?
But on Tuesday, she issued a public apology to Broadwater in which she acknowledged he had been wrongly accused. I am sorry most of all for the fact that the life you could have led was unjustly robbed from you, and I know that no apology can change what happened to you and never will.
What do you think of that apology?
If it's sincerely from my heart, I can accept it.
The publisher of Lucky says it has ceased publication until they decide if the book can be properly revised.
My comment on that is I saw the movie Lovely Bones. It's psychedelic. And when I saw it, I said somebody was smoking something when they came up with this. It's about a ghost that is lured into an underground bunker by a dirty old man type, raped and murdered. And she's trapped between the hereafter and the now. And she can't get to the hereafter permanently until the case is solved, and this guy keeps going and kills other people. So this thing that she's following up on the sequence, it's like when you get into it, essentially she seems to have a fixation on this kind of thing, and you might wonder about it. Now, anticipating your question, the problem with her being held liable or the state being held liable for this guy being in jail for a while is not going to be something resolved by so-called sovereign immunity. The solution is to get the state legislature to return a private act compensating this guy for his wrongful incarceration or his incarceration. The reason that there would not be a sovereign immunity situation is there's a grand jury involved. Grand juries were invented to protect ordinary citizens from the wrongful action of the sovereign, which in this case was literally the king or queen of England. So the grand jury, if they get involved in it, is outside of the sovereign situation. And if the grand jury returns a true bill of indictment, then what winds up happening is everybody who made a complaint or was involved before that point has across the board immunity, which doesn't come from sovereign immunity, but from the immunity of a grand jury taking action. I've had cases like that myself. I'm very concerned with being a judge, criminal court judge, got elected to 2 8-year terms, and having been a defense lawyer for a long time, with what happens when somebody makes improper suggestions, which seems to be apparent in the history of this case. Briefly, about 7, 8 years ago, was at a major restaurant chain, and I used a credit card I usually don't use for such things, and the waitress kept the card for the longest time, and then found out she had attempted to, or an individual had attempted to use my credit card to charge up a PayPal account, but they didn't succeed because the bank caught it. Well, I talked to the branch vice president, who advised that she personally and several other customers of the bank had questionable activity, but I was the only one that was involved with just that business. So all of us described somebody as being a Caucasian female, late 20s to early 30s, with bright red hair, about 20 piercings on each ear, looked like, may have been less, and distinctive tats on the neck. So 2 detectives showed up, and they brought us 5 pictures of black women from one color spectrum to the other, and I went off on the 2 detectives about this, and they wanted to know who I was. So when I told them, the guy said, "Oh my God, you were the first judge who I testified in front of that involved a felony." So he said, "We need to listen to this is Judge Brown." I said, "Okay, now here's what you did wrong." So you see, these suggestions can cause a great miscarriage of justice, but it is what it is. And the remedy, hopefully, is that they will have a private act by the legislature that compensates him, which is something they can do. Now, like in Georgia, they need to have statutory authority so that when somebody is wrongfully prosecuted or locked up like that, some kind of compensation is on the table for him or her to get, because being locked up is a horrible thing, very horrible thing. And it's not the conditions of the confinement. It's the fact that somebody took you as someone who conceives of themselves as a free human being and said, "No, you don't have liberty anymore. You are subject to somebody's absolute control." And that is the punishment, not the conditions of the confinement.
And I just want to add this is when it comes to that Anthony Broadwater case, somebody put she didn't lie. She reported seeing him on the street. He got picked up, then picked another suspect in a lineup, and the prosecutor still had him arrested, charged, and told Broadwater was the right guy. Prosecutorial misconduct. And prosecutors, there are a lot of prosecutors known for doing that. That person's not picked up in a lineup, but the prosecutors say, "No, he's the guy." And when you get on that stand, you say he's the guy.
You'd be surprised at what happens in the criminal justice system. I can't mention his name, and I'm going to alter the circumstances because of confidentiality. But I had a client who was accused of multiple rapes. He was a bodybuilder. And we had a lineup. So I'm sitting there at the lineup and I'm saying, "Oh God," all these women got up to go look, got up out of their seats to go close to take a look. They had him take his shirt off. And I said, oh, hell. So I said, damn, I guess we're going down on this one. Not one of them identified him. And I said, what the hell were they doing? And the detective said they all thought he was good looking. So they wanted to go get up, look at him closer so they could admire him. So anyway, they came up with some more conclusive evidence. So I got a sweetheart deal for the guy, and he didn't want to go to trial so much, but we set it for trial. And on trial day, the victim showed up. When the victim showed up, I said, man, it looks like it's going to be what it is. So he said, I'll take the time. So they offered him a relatively low sentence since the ID was what it was. So we work all this out, and the prosecutor comes over to me and says, I just had the most unusual request. I said, what is it? The victim. She wants me to give the defendant her phone number so he can call her when he gets through seeing his time. She said if it hadn't have been rape, she would have given it to him and she wants some more. So she said, hey, please give him my phone number so he can call me. I said, wow. So I wouldn't accept the number just off of the sense of propriety involved, but you never can tell what happens.
Well, listen, great show. Thank you, Judge. And guys, please subscribe like this video, share this video, and subscribe to the YouTube channel, The Real Dana. And anything in closing, Judge?
Hey, justice grinds slowly.